Had to examine. No? He's on? We had to hear him on this issue only. He had finished.
In fact, my learned friend who's appearing to the UGC was making a endeavor to come to he was buttressing the submission, my lords, that UGC regulations are binding their supreme. There's no dispute about that proposition. We are now saying, my lords, in the affidavit that we will be following the UGC.
Orders, there are already orders of Supreme Court asking you to comply with it.
Please, my lords, but
effective reading of those orders will be complied. So the question is, under what principle can we now alter it?
Please, my lords, only now we have filed an affidavit. We are seeking the indulgence of the court for 1 year extension of the existing.
But under what principle,
my lords?
At least to the extent of persons that you have qualified, persons are available. You can't not follow it.
On the basis of a
on
recent
those that are not available.
Please.
Then we can.
No, my lords. On the basis of a recent decision, which I was not able to place yesterday, I'll just pass it on, my lords. Please. This was in the context, a similar context, my lords, but in the context of a teacher's eligibility test, where the Supreme Court, my lords, finally held it was mandatory. Then, my lords, there were in-service candidates, my lords, who did not possess the teacher's eligibility test. Supreme Court has permitted them 2 years' time.
So, in-service. That is in-service.
In-service, my lords, similar analogy where persons who are already, my lords, been serving from 2003. Page number, para 214, my lords, the last. My lords may see last but one page, para 214.
Yes.
Para 214. Order on applicability of TET to in-service. Further detailed discussions upon resting on the same, we hold that the provisions of the RTA Act have to be complied with by all schools as defined in 2N of the RTA Act, except the schools established and administered by the minority, whether religious or linguistic, till such time the reference is decided and subject to the answers to the questions formulated above under section 7. Logically, it would follow that in-service teachers, irrespective of length of the service, would be required to qualify the TET to continue in service. However, we are mindful of the ground realities as well as the practical challenges. There are in-service teachers who are recruited much prior to the advent of the RTA Act and who might have put in more than 2 or 3 decades, even 3 decades of service. They have been imparting education to the students to the best of their ability without any serious complaint. It is not that the students who have been imparted education by the non-TET qualified.
Nobody getting dislodged here.
Please, minutes.
No. Nobody is getting dislodged.
No, here court said if you don't pass TET, you're out of the job. That is what the court said.
No.
I'll just read
here. They said the qualifications of the teachers are necessary. This is what it said. But they said those persons who are already in service.
Please, minutes.
Then the Supreme Court gave them time to comply.
Comply for 2 years. Failing which, minutes, the court said you will be out of the job.
Correct.
Failing which?
No, in service already
in service.
Your case
analogy,
is not in service.
No, analogy.
You are now appointing them.
No, I'll just give an analogy. I'm not appointing afresh. 2000, I'm just saying from 2003, I have continued certain people.
You said you're having counseling.
That is
counseling is only the point.
Please, minutes, every year, minutes, based on the persons who worked earlier. Minutes, I'll just give a statistics. Even reconcile.
Your case is only choice of guest lecturer.
And we are saying confirm
the memo that you gave. There are 4 subjects. There are sufficient number of persons available.
That is that.
Let's break it down to simple proposition.
Please,
the first proposition is the qualification requirement.
Please.
Your entire appeal proceeds on the basis that guest lecturers are not contractual employees.
Please.
Lecturers, they are other than the education. That you can't be serious.
No, my lords, by filing the
expressed.
Please, lords, based on what my lords have expressed.
That qualification is applicable.
Please, my lords.
You're also to some extent acceptable. Yes, those qualifications you said give us 1 year.
Please.
Now today you have persons who are available.
Please.
Who have the qualifications. So how will you appoint anybody else?
No, it's what we are.
You could have understood if they're already in employment, you had to remove them from service. Removal of service for 20 years entails its own issues. And assuming that we can
No, no.
take a cue on this, we could have
Yes.
passed.
Can I
They're
just
not in
clarify?
service.
Can I just clarify it the other way around? No, it's like this. We are now reconciled to the fact that the single judge's order can be upheld. All we are saying is we'll implement the single judge's order from from 26-27.
They're asking you why.
Why, my lords, for this reason, from 2018 is the regulations that they are seeking to enforce. I have continued, my lords, now for the 2024-25, the guest lecturers who have continued out of 10,000 people, I've given the statistics in my affidavit. 50%, my lords, are persons who have NAT, 50% don't have NAT. The 50% who don't have NAT have been continued, my lords, from 2003 onwards. So what we are saying is, we will be able to continue.
That's not what you're saying. You're
That is
not
what-
saying there is any continuity of guest lecturers.
No,
You are saying every academic year you
We do
appoint them
that.
afresh.
We do that, my lords. Every academic
Every
year we give a
appointed,
break.
you go through counseling.
Counseling.
You appoint them fresh.
Afresh,
You
my
look
lords.
at it. You give them weightage for the services past. You select somebody who's got a higher weightage. You give him
Please,
that.
please, but
You give weightage for education there. And now you say it's continuity.
no,
of
it's
the-
continuing in the sense that in view of the weightage, the persons, my lords, who are working, a temporary person is not replaced by another temporary person, which has been upheld by the single judge also. So what we are saying is, what we continued, as a matter of fact, my lords, from 2003, 1 year permit us to continue. We will finish this year. Academic year has started.
We are nobody to permit you, no. We can't tell you please do a crosser, and we don't have Article 142 with us, even if you were to persuade us.
No, my lords, only that
We have-
judgment
We have
specific.
only looked at the law, so we are looking at the principle of law under which we can help you.
Then, my lords, the other way, my lords, as my lords have pointed out, was only with regard to where there is shortfall of even,
That we can understand exigencies,
because that is exigency, my lords. I get it.
that we can grant you. That will subject to
Yes,
what they say, we will pass.
I
it.
represent the guest lecturers, my lord. We are serving the government as a guest faculty from last 15 years, more than 15 years.
You
my
know
lord.
the qualifications.
So you currently were pursuing the PhD, my lord.
You
So
know
the
that.
outer limit for
Therefore-
completing the PhD is 5 to 6 years, my
You
lord.
could take NET, you could take SET, you could take any one of those. Now the qualifications are not there, under what principle of law can we say no?
More than
you please
50%
continue?
out of 5,000, my lord, they are pursuing their PhD. It's in third year, my lord. Third year we have completed, we have submitted our thesis. So by the time we finish, it will take another 1 year, my lord.
No, okay, I understand the point. The question is, this
See, they have
qualification came out some time
They
ago.
are about to relieve us, my lord, from last 15 years, for more than 15 years, my lord. We are in our 55 years, my lord, actually. We are-
We understand.
So
that.
within 5, 6 years, we are going to retire.
No, we understand the problem. It's not that we are not conscious of it. That's why we are devoting this kind of time, trying to find out whether there is a solution to this. We will let them argue the matter.
For meager sum of 30,000 rupees, we are serving from last 15 years, my lords.
That's the extension that now they are seeking cannot be given, Manoj, because of statement of objection at page 192 of the writ appeal, Manoj. They themselves, Manoj, in their statement of objections before the learned single judge, said they portrayed in such a way that, Manoj, the writ petition is a premature because they have time till 13/1/2025. Manoj, they impliedly assured that all the guest faculties who are they've been appointing will have the necessary qualification by
That's what he
13/1/2025, Manoj.
That's what the,
Now they cannot seek one more year extension.
that's why the council is
Really?
clearly pointing out that as far as those
The
which are not,
university regulation comes
which
in
are
the year
not qualified, you don't have,
2022.
you have seats available and your requirement is there, you don't have qualified persons.
Please, Manoj,
To that extent, you can't come and say that, no,
please.
please don't take guest lecturers at all. That, to that extent, even for some, there may not be specific qualifications prescribed also.
Please.
Only for the extent where adequate
Where-
sufficient number of persons are available,
Where there is shortfall.
where there is a shortfall, they'll be able to try to, for the ad hoc period, continue that.
These minutes, I will leave it because we
Very-
just want a.
That
why
may
does
be
this
made
way or
clear,
rather-
Manoj,
That's
only
one
with
way
the-
of understanding.
That may be made clear, Manoj, where shortfall, wherever, if they are putting it on affidavit, Manoj, it is only for the,
They put a memo, they've
We have
given you,
stated in the affidavit itself that
that's
wherever
the
shortfall.
affidavit, Manoj.
That's what we had stated in paragraph 11 of the affidavit was give us 1 year. From the next year, we'll do that. Now, my lords are not allowing that. My lords can pass any order. Still, my lords,
Your lordships.
can I make one attempt? 1 year, my lords, we'll just.
No,
we have no difficulty, we were willing to give it to you, but the question is, we have to also, we are also bound by
That,
law. No? We are
how
only
this-
trying to think out, tell us on which principle of
On
law
the
you-
principle, my lords, where Supreme Court has permit, that I would say it is analogous. Again, they were in service, my lords.
In service.
In
person,
service.
In a matter which comes, of course they can do it. This is not in service. You're wanting counseling to be completed.
I get it. I will.
Call him on Monday, then we'll pass.
Please,
it on.
please, my lords.
Yes.
Your Lordships, I'm appearing on behalf of the intervening applicants, Your Lordships, who are the UGC qualified candidates who have applied for the post of guest faculty lecturer for the ensuing academic year, Your Lordships. Your Lordships, we possess the minimum qualification as per UGC regulations 2000.
That will be considered.
Yes, Your Lordships, please, if I have placed reliance on the Honorable Division Bench of the Honorable High Court of Chhattisgarh. If Your Lordships may kindly look into the.
You are contesting what he's saying.
Yes, Your Lordships. Your Lordships, this judgment's.
The
other way
UGC is
around.
contesting what you are saying.
Basically,
It's
UGC.
the other way around, my lords.
You don't
They are
need
supporting
to
our
hear-
contentions where
But
UGC
you can give
regulations.
us-
Here for the UGC qualified candidates, Your Lordships.
And UGC is taking care of them. UGC's contentions cover.
The candidates who are qualified as per the UGC regulations 2018, as per the regulation 13, Your Lordships. Your Lordships, if, it squarely applies to the present matter, Your Lordships. If you may kindly look into para 15, Your Lordships. Page number 9, Your Lordships. The appellant or writ petitioner has failed to establish that an ad hoc or temporary appointee cannot be replaced by another ad hoc or temporary appointee. And if a temporary appointee in service is incompetent, can he not be allowed to be replaced with a competent or more competent person? There is no reason why the competent person cannot be appointed in place of the incompetent person when both the appointments are ad hoc or temporary in nature.
This is not about competency. This is about eligibility. That's all.
Yes, Your Lordships,
This
but.
is not about competency. This
But-
is about,
but-
for all you know, the guest lecturers who are 20 years may be more competent.
But Your
The
Lordship,
question is, the rule is whether they fulfill the eligibility condition.
Yes, Your
Eligibility qualification is an issue. This show that memo. which is given. Let's see on which subjects you are short.
Please, Manoj.
Also, some subjects, they said that there is no
Net.
qualification provided for those.
No, Manoj, the rules provide that in the event net or SLET is not conducted in a particular subject, then that requirement is not.
That's right. So that is
That is one exception.
one exception.
And the other exception is where I have shortfall, Manoj, of even UGC.
That is
qualification.
what we are creating.
Please, Manoj.
And in some subjects, that is all that you can react on. Otherwise,
Yes, ma'am. Yes.
Manoj,
can't hold
Those
up-
two
we
points,
can't hold
Manoj,
up their,
Only on those 2 points, Manoj, the
only on those 2 points.
yes, yes, Manoj. I'll counter on those 2 points on Monday, Manoj. if you want to comment.
Put it on Monday. Yes?
My impeding application may
No,
come.
no, no. No question of
I'm representing the guest faculties, my lord.
Monday, Manoj.
deciding on law. That is the question.
Monday, Manoj.
Monday.
Grateful, Your Lordships.